মিনিমাইজ না যদি বন্ধ হয়ে যায়
না মিনিমাইজ করে ওই টেমপ্লেটটা নিয়ে
হ্যাঁ থাক এটাও খোলা থাক এটা কাটি চালিয়ে দিই
ঠিক আছে জাস্টিস সেনকে রিসিভ করতে
চলে যাচ্ছে ফুল স্ক্রিন করে দিই ঠিক আছে থাক থাক থাক
স্টার্ট করব
Good evening, everyone. On behalf of WPNUJS, I welcome you to the second Justice Dr. Radha Binod Pal Memorial Lecture. After the much success of the first international conclave held in ITC and WPNUJS campus in November, this is the second endeavor of this chair, which has been well endorsed by the government of West Bengal. May I request our Honorable Vice Chancellor and our distinguished guests to kindly join us for lighting of the lamp. May I request the Honorable Vice Chancellor to kindly give away the welcome speech.
Very good evening to all of you. It is my pleasure to have this occasion and to welcome you in the program which we have initiated in last November to memorize and to initiate a chair in the name of Justice Dr. Radha Binod Pal, the great jurist in the international law, not only in international criminal law, but in other jurisprudence also like family law, tax law, and also his writings in other philosophical writings also that made him one of the greatest jurists in the world. This initiation of reminding, though sorry, we refer the Tokyo trial and dissent opinion of Justice Radha Binod Pal. But the initiation was to inculcate the reasoning, the philosophy, and also the humanitarian aspect of international criminal law, which was first glimpsed in the dissent opinion, and that was carried on in many aspects and impacts. Keeping in view of that, we initiated that chair. It was in fact proposed by one of our the then member of the Executive Council, Honorable Justice Somen Sen, who is coming and joining within few minutes. He is on the way. And we are also trying to spread the thinking and also the philosophy of Justice Pal among the students, for which we have also initiated essay writing competition on Justice Pal. The first time we have initiated, and the response from the students, not only in India but outside the country also, is enormous. We are very happy that about 80 or more participants joined this essay competition. We have selected 3 first, second, third among the 80 essays we have received by panel of teachers who are in the international law particularly, and we will announce that result also today. We are also planning not only this essay but every year a lecture on philosophy and the perspective of decent opinion, as well as a philosopher, as a jurist, how Justice Radha Binod Pal influenced the even present generation of legal aspects, and also we are thinking to develop this into permanent form from publications. We have initiated the past program, which was in November. We have initiated for publication in book form, and this will continue. That was the first volume. We are thinking to have another volume by this type of lectures and essay competition. We may think of include some essays which are very much appreciable. We can include that in our proposed books, and we can afterwards theme-wise also thinking to publish, and also sometimes we can think of only one aspect of impact of dissent opinion in the present generation. That also we can think of. So our purpose of initiation of the chair, as well as how we'll go further in future, outline we have prepared with Chair Honorable Justice Sen, who chaired in our advisory body. We are glad that Sir joined us. Thank you, Sir, for joining, and we are grateful to that. With us today also the second memorial lecture to be delivered by Professor Dr. Vaisar Murthy, who is from Assam Global University. We are with now Professor Amita Singh, Dr. Diane McGrury from USA, Dr. Stelia Jolly, Debashish Mitro, Mrs. Rohini Sen, Professor Sudhakar, and also family members of the Justice Radha Binod Pal. We are very much grateful to all of you, and also my colleagues and dear students who are with us in this evening. I welcome all of you to this occasion. It is in fact a privilege to welcome you again, and also it is the first lecture which was delivered by Professor Mark. Now we are in the second phase. Our plan is to publish all the series of lecture in the book form. So we are trying to publish as many books, articles to memorize the contribution of Justice Pal. And as we commence this lecture series, and today we have also a panel discussion on the topic role of dissenting opinion in shaping international law, which is very much pertinent to all the youngsters and also to all of us in the today, in not only international law, in other aspects also. This reasoning, how with a sound reasoning, even the whole world can be changed in their perception and perspective. That was the spirit of Justice Pal, how it is percolating, how it has impact in the present day. We are trying to locate that in our discussion, and also to record that. I am confident that this today's panel discussion lecture as well as our observation on the panel that will also reflect how the influence and the writings of Justice Paul still now alive, and we want that it should be alive among the new generations to come. That's why some students are also here to hear how it can change their views on international law, particularly international criminal law. Thank you for joining. Thank you all. I welcome you with this program. Thank you.
May I request the Honorable Vice Chancellor to kindly felicitate our esteemed guests. Firstly, Justice Shoman Shen. Mr. Radha Binod Pal, the third generation of Justice Radha Binod Pal. I correct myself, second generation of Justice Radha Binod Pal. Our keynote speaker, as well as the one who will be delivering the second memorial lecture, Professor Dr. Y.S.R. Murthy, Honorable Vice Chancellor, Assam Global University. As we were contemplating in organizing the first birth anniversary celebration of Justice Radha Binod Pal, it did come to our surprise that it was on a Monday and definitely after a national holiday. And who's been the strong force of habit? Of course, it was Justice Shoman Shen, who's been one of the pillar of support throughout for this chair and of course for multiple number of conferences that we are about to hold as well. May I request Justice Sen to share a few words?
Honorable the Vice Chancellor, the distinguished academician, guests, speakers, participants, and all present dignitaries present. Dr. Pal was always in my heart since, if I say my school, from my college days. In fact, my recollection was that when I was a student of law, it would be in the year 1989 possibly, that my father presented me a book which was lying neglected in a bookstore near the High Court, Church Lane. He bought that book, maybe the first one published by Shannal Publishing House. And few pages were missing. So my father told me he gifted this book to me when I was a student. And in fact, that time we were studying international law, and the book that was prescribed and we always follow was Stark on International Law. And I was working on diplomatic immunity as a subject on which I had to deliver it in a moot court competition, preparing myself for that. So he gifted me that book and said that, read it whenever you get time. One of the most scholarly judgment and maybe the first in the world when the tribunal was constituted and an international tribunal deciding on the fate of the vanquished has been so well articulated. So if you get a time, you read this, you will find the history of warfare, how they conduct themselves and what are the rules of the game. That time I read it, yes, no doubt. But as the time goes, and as I go through his life, his literature, and even my experience at the bench, I started thinking that what is the impact of dissent? Because you see that when Justice Pal, he was not the original 11 who were selected for the tribunal. He was a late entrant. When he entered the tribunal, when he became a judge in the tribunal appointed, it was almost for everyone a foregone conclusion. 8 of them already decided that they will deliver a judgment following the Nuremberg. They say it's a precedent. I follow the doctrine of precedent. It is easier for us to deliver a judgment. So 8 of them are almost certain to deliver a judgment on that. So it is Justice Pal who went there, read the charter, and said, no, sorry, I can't agree with you. You may have your opinion. So what is most important is that not that we are here to either reaffirm our faith in Justice Pal or not, but what is important is that respect for the other view. See, the composition of the tribunal will give you an impression that most of them are likely to be biased. Real likelihood of bias or likely to be biased. Even if we not dilate on this, the most important fact is that the persons who are facing the trial, what they feel about the composition of the bench. Are they in a position to say that, well, having regard to the composition of the bench, I can say that the members of the bench, they are all free of any biasness. Now it is in the context of their appointment, the charter, and the more fundamental principle which he raised in the tribunal and made 2 or 3 of the judges thinking. Because before he went there, everyone says that we are going to write the judgment. It's very short, follow Nuremberg as a precedent. So for Paul to go there and say that no, we raise a question of jurisdiction. The first elementary principle. Even in our law we say that there is a distinction between the court and the tribunal. Tribunal is a creature of a statute. The inherent power of the courts may not be the power bestowed upon the tribunal. So the jurisdictional issue he raised in the tribunal is very important. Can you include a head of crime which at the time when this offense was created was not an offense, either by the 1937 or the Paris Pact. It was never considered to be a head of any crime on which they can be prosecuted. Apart from that, he also very meticulously studied the factual aspect of his evidence. So this 1270, 1240 pages, he has not only traced the history of the warfare, but he also analyzed the material facts and the evidence on record to show that whether even on merits, it could be said, you could give such a sentence or not. So if you have no jurisdiction elementary, then of course you cannot decide the fate of it. The other important thing he said is also very important, that will they get justice? You may persecute them, you may hang them. But at the end of the day, when we go to the gallows, will not they think that injustice is caused to us? I can deliver a judgment, even at the end of the day, the accused may feel that yes, he was hurt, then on merits he lost. But if it is perceived from the very beginning that I will not get justice, so it's really a mock trial. So these 2 very fundamental things he raised, and even in analyzing this, he said that when a distinction comes between the sovereign and the acts of individuals, he's very clearly said that even our law, the traditional law, even the Vedic philosophy, it does not even absolve the God if the God acts arbitrarily. He said what we as a nation, as a philosophy, what we respected is the divine reasoning. The divine reasoning is most important than a divine will. The divine will cannot be applied arbitrarily. So the reasoning, the sense of reasoning, and no one is superior to law. These are the most important things which he wants to really articulate in his judgment. And he was a face, I would say, for the third world. Even after his decision, one could find out that, well, the colonial rules are gradually declining. There are a lot of these third world countries are emerging. He was an emerging face. He was a voice for the third world. So these are and that is why he said that respect for the other views is most important what Paul has established by his judgment. No one could have ignored when he was not, I am told that he was not even allowed to read the judgment. That's a different issue. Again, again, a view of the victor's justice is victor's justice, which is very much evident from the conduct of the proceedings. But what is important is this, that his judgment is read, and if you see, there are, even in domestic law, I can tell you that 3 instances I can give. One was the instance where it's a law of preventive detention. I just take a few minutes on this. In the law of preventive detention after independence, there was a lot of debate on this. Those who fought for the freedom in the Constituent Assembly debate, how they could persuade themselves to accept that law of preventive detention should be there or not. Now here, I would quote one of the celebrated judges of post-independence, Justice. Sorry.
না স্যার আমি করে দিই
আমি এখানটা হাত রাখছি নাকি
স্যার আমি করে দিই
sorry I have not.
আচ্ছা আমি এটা স্ক্রিনটা একটু এবার আপনি হাত রাখুন
So the first reference would be of Justice Vivian Bose. Vivian Bose was a crusader of personal liberty, and in his dissenting judgment in S. Krishnan Kotha versus State of Madras, it was in 1951, Supreme Court 301, in the context of the validity of preventive detention, Amendment Act 1951, he observed, I cannot bring myself to believe that the framers of our Constitution intended that the liberties guaranteed should be illusory and meaningless, or that they could be toyed by this person or that. They did not bestow on the people of India a cold, lifeless, inert mass of malleable clay, but created a living organism, breathed life into it, and endowed it with purpose and vigor so that it should grow healthily and sturdily in the democratic way of life, which is the free way. In the circumstances, I prefer to decide in favor of the freedom of the subject. Now, you find echo of this in a celebrated judgment in Liversidge v. Anderson of Lord Atkin. It was decided in the year 1942, I believe, 1941. It was in the context of the detention during the trial, during the emergency power exercised by Lord Atkin, exercised by the British Parliament. So in that, Lord Atkin said, again, he espoused the cost of individual liberty. And he said that in the by of an emergency, or by using the expression reason to believe, you cannot curtail the right to freedom. It is in the judicial review lies for deciding what are the reasons. If you do not disclose the reasons, then the entire process is faulty. The same reasoning we find when we consider the judgment in ADM Jabalpur of Justice Khanna, H.R. Khanna. So all these are dissenters, but these all views later on, because Lord Atkin's view has been upheld later on by the House of Lords in 84. So far as Justice Vivian Bose is concerned, there's a change in the law of preventive detention, advisory board and other things were made, so as to make it look transparent. And we all know that ADM Jabalpur has been considered by a later bench in Puttaswamy case, and thereafter also holding that the dissenting view of Khanna was the right view. Similarly, you will find that in this deliberation to come out, there are 3 at least cases. I will not discuss those cases in detail. One was the opinion of Judge George Gallagher King in the Fuana case of the Special Court of Sierra Leone. The other one is of the Azerbaijan's case. So these 2 cases, again, you will find one of the issues came up for consideration is the jurisdiction of the tribunal. What would be the critical date? How the offense is to be addressed? So I will not go into this in detail, because I am sure that this will come up during deliberation. But what I mean to say is this, that what Justice Pal had done to the international community, to the international justice system, is that he made the tribunal to apply their mind and to decide, and not to brush aside that, well, you are not required to be heard. Is a respect for the other view is what is most important. That on the same set of facts, there are two views possible. And of course, the majority view you have to accept because of majority. But that doesn't mean that what is a minority view today could not be a majority tomorrow. There's always a chance of correcting your error. The dissent has this advantage that in future, when similar situation came up for consideration, then the bench had the opportunity to also consider whether, in the given facts and circumstances, considering the approach object, whether that view was the correct view at that point of time, or that view should be accepted today or not. There lies the beauty of dissent. I thank the Vice Chancellor and the University for inviting me, and I hope that these kind of deliberations will continue throughout the year, and we get enriched by the discussion. Thank you.
Thank you, Justice Sen. May I request Mr. Pal to share a few words, maybe just a couple of words as the birth anniversary of Justice Pal.
Good evening. Hello. Good evening. Honorable Justice Shomen Sen, Honorable Vice Chancellor, NUJS, Professor Dr. Nirmal Kanti Chakravarti, distinguished eminent dignitaries present here, ladies and gentlemen. Today is the auspicious occasion, 139th birth anniversary of my late grandfather, Justice Dr. Radha Binod Pal. It gives me immense pleasure and pride in addressing this august academic gathering at the second Justice Dr. Radha Binod Pal Memorial Lecture, whose dissentient judgment at the Tokyo trial still has a perennial legacy in the realm of international criminal law and jurisprudence. More so, this has relevance till date, so far as the ambit of Webster's justice is concerned in a global order. Therefore, his judgment indeed has opened up a new dimension in the arena of international humanitarian and war crimes law, which is still being researched and debated upon worldwide. We, on behalf of the family of Justice Pal, are indeed honored to be part of this lecture organized under the auspices of WBNUJS, wherein experts in international criminal law have assembled here to enrich the academic aura of this gathering through their erudite deliberations. Some of the family members of Justice Pal have also been proudly part of the pioneering international conflict organized by WBNUJS in November 2024, wherein a chair post and a Center for International Criminal Legal Studies dedicated to Justice Dr. Radha Binod Pal was inaugurated, which has only been funded by the government of West Bengal. Our heartfelt, sincerest thanks to both the legal department of West Bengal and the management of WBNUJS for taking all important steps for organizing such events on regular basis, which is a pioneering effort of sorts in this part of the country. Many of you present here may or may not be aware that Justice Pal came from a very ordinary rural background, but with the untiring efforts of his mother and himself, he established himself academically and achieved many great laurels in his professional career. Justice Pal was also a great philanthropist who single-handedly took care of many brilliant students at their very young age, provided them with all sorts of necessary support till they were academically well established in their respective field of studies. Later on, he even went ahead and integrated some of them in his own family. Therefore, we family members of Justice Pal request the management of WBNUJS for initiating a scholarship program dedicated to the memory of Justice Dr. Radha Binod Pal, primarily for brilliant underprivileged students till they are academically well established. I have already discussed this with Dr. Chakraborty before this event, so he said he will definitely look into this. Before I end, on behalf of all the existing family members of Justice Pal, we wish to once again reiterate our request through this platform to the government of West Bengal and their concerned authorities to rename one important road in North Kolkata, preferably Bedin Street, where he lived for almost 31 years, and one smart park in South Kolkata, again preferably in New Alipur, because there he resided in the last part of his life till from 1954 onwards, in the memory of Justice Dr. Radha Binod Pal, which will be a great honor to his legacy and pride for all his family members in our homeland. Finally, we all present family members of Justice Pal once again wish to sincerely thank the government of West Bengal, the management of WBNUJS, Vice Chancellor Professor Dr. N.K. Chakraborty, Coordinator Mrs. Shaili Chakraborty, and all the members of the organizing committee for their continued pioneering efforts in honoring and memorializing the legacy of Justice Dr. Radha Binod Pal. With this, I conclude my address. Thank you for all your patient hearing.
Thank you, Mr. Pal, and you'll be happy to know that the picture and also the judgment that you have given to WBNUJS is safely there at one of the more coveted rooms as well. May I request our keynote speaker, Professor Dr. Y.S.R. Murthy, to kindly give away the second memorial lecture.
Honorable Judge, Calcutta High Court, Mr. Justice Soman Sen, Honorable Vice Chancellor and Professor and President, Indian Society of Criminology, Professor Dr. N.K. Chakraborty, Mr. Sudhi Binod Pal, Mr. Sridevi Nair Pal, Dr. Madhumita Roy Pal, and other members of Dr. Radha Binod Pal's family, academics from India and abroad, NUJS faculty members and students. I wish to thank West Bengal National University of Juridical Sciences, and in particular, the Honorable Vice Chancellor, Professor Dr. N.K. Chakraborty, and also Professor Sudhakar for inviting me to be a part of this prestigious Justice Dr. Radha Binod Pal Memorial Lecture. I deem it a great honor and privilege to deliver a lecture instituted in the memory of an extraordinary judge. I have visited NUJS several times when eminent scholars and stalwarts like Professor M.P. Singh and Professor Chimney were steering this institution. It is nice to be back again at this prestigious seat of legal learning, started by the doyen of Indian legal education, late Professor N.R. Madhava Menon. NUJS has produced many outstanding lawyers and law teachers over the years. It is truly an inspiring moment for me to set foot on this great campus again and interact with its students, faculty members, and top leadership. In 1998, as a student at the University of London, while I was researching on the international criminal justice, and in particular about the Rome Statute of the International Criminal Court, I became familiar with Justice Dr. Radha Binod Pal and the significance of his work. I have not had the opportunity to meet him in person, but I have had the chance to work closely with his grandson, Mr. Satyabrata Pal, for several years, when he was member of the National Human Rights Commission. Mr. Satyabrat Pal was a fine Indian Foreign Service IFS officer and held very sensitive assignments like the Indian High Commissioner to Pakistan. Above all, he was a man of great learning and carried himself with great dignity. With a passionate and caring heart, he discharged the responsibility of member NHRC with great distinction and was trusted by the civil society. It is significant to note that many of his contemporaries and those who followed him in National Human Rights Commission could not earn a similar trust of the civil society. Seeing the grandson, Mr. Satyabrata Pal, I can only imagine what a towering figure Justice Dr. Radha Binod Pal might have been. He was respected in India and Japan for his extraordinary courage, commitment to rule of law and justice. Who can forget his lone dissenting voice in the International Military Tribunal for the Far East or the Tokyo Tribunal, when he held that all defendants were not guilty for compelling reasons rooted in law. To go against the majority or swim against the tide are not easy options. When Nuremberg Tribunal and Tokyo Tribunal started their work, the crimes that they were trying to prosecute, namely crimes against peace, war crimes, crimes against humanity, were not fully codified. It raised serious problems of legality in criminal law, the prohibition against ex post facto laws, and the Latin maxim to the effect that no crime, no punishment without a previous penal law. How can you apply the newly created norms exclusively to the vanquished? Will it not amount to double standards? And will it not amount to victor's justice? Justice Dr. Radha Binod Pal took that stand, and with legal justification. I pay my humble tribute to this great son of India on the occasion of his birth anniversary for going down in the history of international criminal law, for his bold stand, and in the process making himself and his country proud. Before I take up contemporary threats to international criminal justice, I would like to give a brief review of the historical context. The first reference to a tribunal to try international crimes is contained in Article 227 of the Treaty of Versailles. Concluded at the end of World War I, it provided for the prosecution of Wilhelm II before an international criminal tribunal for the supreme offense against international morality and the sanctity of treaties. Of course, it's another matter that it did not take off owing to a lack of political will. Sheriff Bassioni, who is regarded as the father of international criminal law, identified 25 categories of international crimes based on 10 penal characteristics. An analysis of these 25 categories of international crimes shows that the proscribed conduct affects a significant international interest, including threats to peace and security, or commonly shared values of the world community, including conduct shocking the conscience of humanity, or involves more than one state or transnational implications. The underlying idea seems to be that those crimes cannot be prevented or controlled without their international criminalization. The rate and pace of international criminal law elaboration quickened in the 1960s and accelerated in the late 1970s, one of the reasons being the concern and attention given to human rights and to the criminalization of their violation. The tragic irony, critics say, was that the international human rights law, the international humanitarian law gained wide acceptance in the 20th century, but were seldom enforced. Situation, however, improved in the 21st century, but the emergence of new challenges are posing grave questions. Are there threats to international criminal justice? Yes, there are many, with some of them being very sensitive and intractable ones. I'll outline a few of them today. Genocide is regarded as crime of crimes, most egregious crime, despite the Genocide Convention of 1948, wealth of jurisprudence evolved by the International Military Tribunal for Yugoslavia, ICTY, and the International Criminal Tribunal for Rwanda, ICTR, and despite coming into force of the International Criminal Court in 2002, there still exist several situations which can be regarded as genocidal. For instance, Darfur in Sudan, Myanmar action against Rohingyas, Chinese action against Uyghur Muslims, Israel's action against Palestinians in Gaza, and several other situations. In the past 2 years, there have been numerous reports of serious violations of international law by Israel in Gaza. Here are some key points. Since October 2024, the Israeli military has imposed a siege on significant parts of North Gaza, leading to catastrophic humanitarian conditions. Over 100,000 Palestinians have been displaced, and those remaining have been deprived of essential resources like water and food. Following Hamas' attack on Israel in October 2023, Israel launched a bombardment campaign on the Gaza Strip. This campaign has led to significant civilian casualties and destruction of civilian infrastructure, including hospitals. The UN Human Rights Office has documented numerous violations of international law, including the killing of civilians and breaches that could amount to war crimes. These actions may also constitute crimes against humanity and genocide if committed with intent to destroy a particular group. You can very well guess whether this is attracted or not. The International Court of Justice, ICJ, issued provisional measures on January 26, 2024 in the case brought by South Africa against Israel. ICJ asked Israel to take all possible measures to prevent genocidal acts as outlined in Article 2 of the 1948 Genocide Convention, and asked Israel to ensure that its military does not carry out actions that could be considered genocidal. And ICJ ordered Israel to immediately cease its military offensive in the city of Rafah in southern Gaza. Despite these directions by ICJ, despite concerns expressed by UN, reports indicate that Israel has not fully complied with ICJ's orders. The disdain with which states have treated the United Nations, ICJ, obligations under the international human rights law, international humanitarian law, and international criminal law pose a grave threat. This disdain has increased particularly in the last 4 or 5 years. The Russia-Ukraine conflict has several serious violations of the international law. Russia's invasion of Ukraine in 2022 violated Article 2.4 of the UN Charter, which prohibits use of force against the territorial integrity or political independence of any state. The invasion and subsequent military actions can be regarded as war crimes and acts of aggression under the Rome Statute. This includes targeting civilians, using prohibited weapons, and causing widespread destruction. There have been continued violations of international humanitarian law, including attacks on humanitarian personnel and facilities, forcible transfers and deportations of civilians, and the destruction of critical infrastructure like the Kakauka Dam. Reports indicate arbitrary deprivation of liberty, enforced disappearance, and torture in areas under Russian control. The conflict has led to significant forced displacement and unlawful evacuations, with civilians being forcibly transferred and subjected to filtration process by Russian authorities. These violations have had a devastating impact on the lives of civilians and have drawn widespread condemnation from the international community. The Syrian conflict has seen numerous violations of international law, including the use of chemical weapons. All parties involved in the conflict, including the Syrian government, opposition groups, the extremist organizations like ISIS, have committed serious violations of IHL. These include targeting civilians, using prohibited weapons, and attacking protected objects like hospitals and schools. As regards use of chemical weapons, there have been several instances during the Syrian civil war. The most common agents used were chlorine, sarin, and sulfur mustard. The Syrian government and ISIS have been implicated in these attacks, with the majority carried out by the Assad regime. The use and testing of lethal technologies in recent conflicts have raised significant concerns. It is as if the world is a laboratory and the military-industrial complex or the powerful countries are testing these technologies which are being developed at theaters of conflict. I'll outline some of them. Lethal Autonomous Weapons Systems, or LAWS. These systems, which can select and engage targets without human intervention, have been developed and tested by several countries. They have been used in conflicts like the Azerbaijan, Armenia, Russia, Ukraine, and Israel-Hamas conflicts. Artificial intelligence, AI in warfare. AI has been integrated into various military applications, including unmanned combat aerial vehicles and autonomous ground vehicles. These technologies have been used for surveillance, target selection, and even combat operations. The use of these technologies raises ethical and legal questions, particularly regarding accountability and the potential for misuse. International bodies like the United Nations have called for legal frameworks to regulate the use of AI and autonomous weapons in conflicts. These developments highlight the need for careful consideration and regulation to ensure that the use of lethal technologies does not exacerbate conflicts or lead to unintended harm. The rise of killer robots and autonomous weapon systems presents several challenges to international law. For instance, one of the primary challenges is determining who is responsible for actions taken by autonomous systems. Traditional IHL principles hold humans accountable for decisions in warfare, but AWS complicates this by introducing machines that can make decisions, including kill or not to kill, independently. IHL requires that parties to a conflict distinguish between combatants and civilians and ensure that attacks are proportionate to the military advantage gained. AWS may struggle to accurately identify targets and assess proportionality, leading to potential violations of these principles. Ensuring meaningful human control over autonomous weapon systems is crucial. There is ongoing debate about the level of human involvement required to comply with IHL. Some argue that AWS should be banned entirely, while others believe that with proper regulation, they can be used in compliance with the international humanitarian law. AWS must undergo rigorous legal reviews to ensure that they comply with IHL. States must ensure that the use of autonomous weapon systems by their military forces complies with international humanitarian law. This includes establishing frameworks for state responsibility and individual criminal responsibility for violations. These challenges highlight the need for robust legal and ethical frameworks to regulate the development and use of AWS, to ensure compliance with IHL, and protect civilians in conflict zones. Recent conflicts have caused significant and long-lasting irreversible damage to the natural environment, including in Ukraine, Sudan, Gaza, Burkina Faso, Mali, and Haiti. The environmental impact of these conflicts is often overlooked but has significant long-term consequences for public health, food security, and overall sustainability. Efforts to monitor and address these environmental damages are crucial for rebuilding and ensuring a safer future for affected communities. In the international criminal justice framework, the International Criminal Court at The Hague occupies a pride of place. The adoption of the Rome Statute for ICC in 1998 was hailed as a great development. It was regarded as a paradigm shift from standard setting or norm setting to enforcement, from impunity to accountability. But ICC's working over the last 22 years presents a mixed bag. I will share some positive developments followed by highlighting some serious challenges. The ICC in early 2021 handed down a guilty decision in the case of Ugandan Lord's Resistance Army commander Dominic Ongwen. His conviction for the crime of forced pregnancy is a first for the court and only the second for sexual and other gender-based violence crimes. This seems to indicate a commitment by the ICC to target gender crimes, which are rampant around the world. In this vein, the court was also appointed a focal point for gender equality on 8th March 2021. On the same day, the ICC issued a reparations order to victims from the Democratic Republic of Congo in the case of the prosecutor versus Bosco Ntaganda. Ntaganda was found guilty on 8th July 2019 of war crimes and crimes against humanity. ICC Pre-Trial Chamber 1 issued its decision on the prosecutor's request related to territorial jurisdiction over Palestine in February 2021. Keeping in view the political situation, it was indeed a very ambitious, a courageous step on the part of ICC. Seeking accountability for war crimes in Palestine under the International Criminal Court's complementarity regime will be a very big challenge indeed. Israel can claim a robust legal and institutional framework and engage in sham investigation for many years, during which time crucial evidence could be lost, thereby defeating the international criminal justice. In another important 2021 development, the ICC and Sudan agreed to cooperate concerning a case against Sudanese Janjaweed commander. The commander is alleged to have cooperated with the Sudanese government in committing atrocities against Darfur opposition groups. What this means for state cooperation with Sudan as far as former President al-Bashir remains to be seen, but hopefully the ICC will be able to get Sudan to cooperate on all the cases from the country. The ICC needs to ensure that cooperation with it by states is not selective and for some cases only. Thus, the Sudanese situation may be an important marker for state cooperation. Has ICC become an Africa-centric court with the alleged targeting of African states and their victimization? Burundi has left the Rome Statute or ICC, while Gambia, South Africa, and a few other African states have threatened to do so. Has ICC become a court to try only acts of non-state actors referred by states parties? Is it only after small and medium countries? What about the big fish? Is Sudan referral by the UN Security Council a political one? Can UN Security Council, a political body, have a role in legal matters? These are all very important questions indeed. ICC suffers from a number of lacunae, which include, among others, state cooperation, resources or funding issues, ineffective enforcement, lack of adherence to international law by states. The need for state cooperation can be seen in the fact that about a dozen of the ICC accused are fugitives and still not in the hands of the court. The Republic of Malawi and Republic of Chad have refused to comply with the cooperation requests issued by the International Criminal Court with respect to arrest and surrender of Omar al-Bashir. Scholars have commented on the International Criminal Court's ineffective enforcement mechanism. Speedy and prompt investigation and prosecution of international crimes is required to prevent impunity. There is a need for reform of the ICC to ensure state cooperation. The attitude of the United States of America towards the International Criminal Court is a very problematic one. It has adopted a domestic legislation which is labeled by the critics as the Hague Invasion Act. There are differences in the approach between the Biden administration and Trump administration regarding ICC. The Trump administration earlier on revoked the ICC prosecutor's US visa shortly before the ICC pretrial chambers consideration of the situation of war crimes in Afghanistan. With Trump administration back at the helm, one can only guess its consequences for the International Criminal Court and international criminal justice. Thus, the court is making some progress by taking some new cases from all parts of the world, including from states previously seen to be immune from the reach of the ICC, particularly Afghanistan and Palestine. It has also been finalizing more cases. It has been successful in giving victims a voice which they would otherwise not have had. It is still very difficult to prosecute the heads of state and other senior state officials. At present, 123 states are members of the court. Therefore, about 80 states are not part of the ICC process, including large and powerful ones such as US, Russia, China, and India. This has meant that there has been much criticism that the court is meant to deal only with weaker states. The lack of accountability for powerful states has been a key criticism of the International Criminal Court. After protracted negotiations by member states, the crime of aggression was added to the court's arsenal in 2017. However, no case has been brought against anyone, nor is it likely that many, if any, cases will be brought, despite the huge number of conflicts which are on the rise. For the ICC to impact the situation on the ground and try to reduce the effect of such circumstances, it ought to try and play a deterrent. Terrorism or international terrorism also poses several challenges to the international criminal justice. A lack of universally accepted international definition of terrorism creates challenges for effective prosecution and prevention. Responding to terrorism requires balancing complex and competing interests, including civil liberties like privacy. Effective action against terrorism requires cross-jurisdictional cooperation. The need to prevent terrorism can cause an erosion of civil liberties. Let me turn to the new technology and online harms. Technology enables novel forms of perpetration of existing international crimes and entirely new crimes. While digital evidence can improve accountability, it also introduces challenges for investigations and trials. The spread of hate speech and disinformation online can be linked to international crimes such as genocide. Sexual abuse in online spaces is an emerging issue that must be addressed. Any criminalization of online harms must be balanced with the right to freedom of expression. Crimes committed in cyberspace create jurisdictional complexities. We are living in an age of artificial intelligence, deep fakes, newer transnational financial crimes. All of them require appropriate legal codification. The rapid pace of technological development introduces new challenges to international criminal justice. There is a pressing need to adopt international criminal law frameworks to include online harms while simultaneously protecting fundamental rights. The internet's borderless nature adds complexity for the investigations and prosecutions. The destruction of homes is a significant issue, especially in conflict zones like Gaza, where a large percentage of infrastructure has been destroyed, leading to displacement and homelessness. There is a need to codify and criminalize domicide, which is deliberate, widespread, systematic destruction of home. As you can easily appreciate, home is more than a physical structure. It is a place where history and memory are transmitted, preserving cultural and national identity. Home is a place of stability and space for everyday life. Despite the importance of home, international law has little to say about it, with no explicit protection for home or domicide, not yet considered as a crime. While international law is silent on the concept of home, it does shape the conditions of home through human right to housing, property, and privacy, and the protection of civilian objects during conflict. International law also draws equivalence between state and home and seeks to secure conditions of stability and order similar to the structure of household. Renowned scholar Henrietta Gifford, writing in the London Review of International Law, argues that domicide is not just about legal accountability for perpetrators, but also about understanding the violence done through and to home in support of settler colonialism, ethnic oppression, apartheid, and genocide. It is about acknowledging and earning for home and violence done in the name of the yearning. In conclusion, soon after the adoption of the Rome Statute for the International Criminal Court way back in 1998, I posited a question: would ICC lead to a fair, independent, and effective court that will take up egregious violations wherever they occur and by whomsoever committed? After a critical evaluation of its positive and negative features, I observed that the future ICC would be effective institution if there is sustained commitment by states to the ideals of the court. The Rome Statute is neither international treaty making of historic proportion, as has been touted by some, nor a complete delusion. It marks a good beginning, but requires radical improvements to make it more effective. Looking at the situation, now after nearly 25 years, I still hold the same view. In the same vein, the international community has a long way to go for addressing the contemporary threats to international criminal justice. I once again thank the NUJS and its Vice Chancellor, Professor Dr. N.K. Chakrabarti, for giving me the opportunity to share my views with you. Thank you for your attention.
Thank you, Professor Murthy, for such an insightful session. Now we move on to the next part of the program, which is the panel discussion. May I request our panelists to kindly join us on the stage. Professor Dr. Amita Singh. May I request our Honorable Vice Chancellor to kindly felicitate our panelists. They'll come. Okay. Dr. Stelina Jolie, Dr. Dan Maguire, Dr. Devashish Mitro, Professor Dr. TVGNS Sudhakar, our very own professor, Ms. Rohini Shen, may I request all our honorable panelists to kindly join us on the stage. This session is going to be moderated by Honorable Vice Chancellor Professor Dr. N.K. Chakraborty. The session is themed on the role of dissenting opinion in shaping international law. May I request Justice Sen to kindly stay with us at the very table itself. We'll get another chair. May I request our Honorable Vice Chancellor to kindly felicitate our distinguished guest, Dr. Diane McGuire, who is also a Fulbright Scholar to WBNUJS from St. Louis University, the United States of America. May we request to kindly pose for the picture? Professor Dr. Amita Singh, should we say also our very own adjunct professor. Professor T.V.G.N.S. Sudhakar, Professor, the West Bengal National University of Juridical Sciences. Dr. Stelina Jolly, Associate Professor, Faculty of Legal Studies, South Asian University, New Delhi. Dr. Debashish Mitra, Associate Professor and Head, Department of Political Science, Diamond Harbour Women's University. And finally, Ms. Rohini Sen, Associate Professor, OP Jindal Global University, who's just taken a step outside. She'll be joining us very soon. May we request our moderator as well as our Honorable Vice Chancellor, sir, to kindly moderate the session on the role of dissenting opinion in shaping international law.
Rohini ke ekhane de do. Na sit there.
May I request the Honorable Vice Chancellor to kindly felicitate Rohini as well.
So we are to start our next session on panel discussion. The topic already Soili announced, the role of dissenting opinion in shaping international law. In fact, it has very wide perspective. Anyone can go any other area of international law or any area of international law where dissenting opinion or dissenting note, and also the controversies on dilemmas on international legal regime that can be brought into under that. Because of paucity of time, we have decided that first of all we will request all the panelists to have about 5 to 7 minutes some comments, then there would be some common discussions on them that would be moderated, and if any questions from the floor that will be coming. So we'll start with Dr. Stelina Jolly. She is to catch the flight, so I request Stelina to start.
Hello, hello.
Respected Honorable Justice Somen Sen and Honorable Vice Chancellor NUJS. First of all, let me thank Sir Haley for inviting me to be part of this event. And also congratulate NUJS for organizing this lecture on the birth anniversary of Justice Dr. Radha Binod Pal. In the earlier section, Honorable Justice Soman Sen said that Justice Binod Pal's dissent is a reflection of the fact that you need to respect the opinion of others. And Professor Murthy talked about it requires a lot of conviction to articulate a dissent. I'll start from there. So I'm sure, given the background at that time, the World War, the colonialization, so it must have taken a tremendous amount of personal conviction, individual conviction, political and legal conviction on the part of Justice Binod Pal to articulate a dissent opinion, knowing very well that the entire other majority has a different and he's the lone voice. But along with that conviction, in articulating a dissent, it also requires a certain amount of courage, again, the legal and the political courage. In addition to that, I will also add, but that dissent or dissent of any, even in a domestic decisions or in an international forum, dissent brings a kind of a deliberation to the entire discussion. It also appears that otherwise the majority voice becomes the kind of a driving one, and it steers a certain kind of a narrative or a debate, the possibility of a narrative and debate emerging. So this particular dissent actually gives a kind of an opinion that, okay, there is a deliberation, somebody is dissenting to it. And in many of the dissents, if you look at it, it may have an impact, possibly that dissent can become the majority. So I believe that Justice Dr. Binod Pal's dissent has influenced international law in tremendous ways. Maybe to some extent, even intellectual genealogy of the third world approach can be to a great extent traced back to his opinion and his how he linked the entire colonialism with international law. So such definitely has been the impact of his opinion, and not only in the field of criminal law or certain particular branches of international law, whether it is international environmental law or any, like I specialize in international environmental law, I can very well say that the entire the fight of the global south has been for legitimacy starting with the Stockholm, whether it was a question of a legitimacy in terms of representation or in terms of participation or in terms of being just heard. So I think that is the kind of a fight Justice Binod Pal represents. But taking from that particular point, if I look at the role of dissenting opinion in international law per se, I see not much literature has or research has been developed in this area. In comparison to that, you just look at the domestic judicial decisions, you have a lot of tremendous amount of literature has been developed, why, and there has been a research on the dissenting opinions in the judicial forum. So when you look at the international law, not only that there is a lack of adequate amount of literature or a research, you also see a certain kind of a pattern. When you look at ICJ or ITLOs as a judicial fora, you have seen that historically the judges has been using their separate independent opinion or a dissenting opinion. But when you look at judicial forum like WTO for that matter, they don't actually encourage much of a dissenting opinion. So that's something, an interesting point to note that. Is it the history of that particular organization or institutions or negotiations, or is it the kind of an areas which is dealing? It is to be noted that even in the WTO, there is no explicit prohibition in terms of a dissenting opinion, but you do not normally find a kind of a dissenting opinion from all the international law fora. But at the ICJ and other fora, the judges definitely has been particularly using it. So as I said, I research in the area of international environmental law. So Justice Veeramantri has been perhaps influenced by Justice Binod Pal, in many of his decisions actually represent, you can see a kind of a parallel between Justice Pal's opinion and Justice Veeramantri's opinion. Couple of points I wanted to highlight. I think both Justice Veeramantri and as well as Justice Binod Pal had a lot of legal conviction in terms of the point that they felt that in an opinion, even if it is their voice is minority, it may not be making a difference, but they felt that their opinion really needs to be heard. So for instance, in the use of force case, Justice Veeramantri goes on to say that, I know my opinion is minority, it is not going to make a difference, but I feel obliged to express my opinion and possibly in future, this may have some kind of a validity. So you can see that parallel between, Judge Binod Pal's opinion and Justice Veeramantri, that they have a very, very strong individual conviction in terms of how their voices has to be heard. Secondly, if Judge Binod Pal's understanding of international law is founded on the background of colonialism, Justice Veeramantri's idea is in a way also reflected the rule of law, not just as a kind of a principle, but also the way that the legal structure and dynamics of the international law functions. And you can see that reflection in his judgments, where you can see a rejection of formalism and an idea of idealism in the sense that how the law should be. Again, in the nuclear advisory opinion, Justice Veeramantri says that the idea of fairness and justice are inherent part of international law. I believe that is a correct reflection, but maybe it is his idealism and belief in the fairness and justice actually talks about it. But rather than trying to only look at and highlight the positive element that always the dissenting judgments are good or what is the impact, I think it needs to be definitely contextualized. So for instance, while Justice Veeramantri has been giving dissenting opinion in many, many judgments, you will see that while during his term as an acting vice president of the International Law Court of Justice, none of his decisions actually reflect a dissenting. So that's an interesting point to study. Is it that maybe Justice Veeramantri was able to persuade others in his opinion, or is it the institutional constraints in which he has to operate? But nevertheless, in many of the environmental law cases, he gave dissenting opinion. But as I said, it needs to be contextualized. For instance, in the case of Gapchikova-Nagimaras case, a bilateral issue between two countries regarding the water sharing. If you look at international environmental law, we understand the language of sustainable development. Indian judiciary has eloquently said sustainable development is a customary international law. So while deciding the case, the majority judgment looked at sustainable development as a concept, not even as a general principles or any. So it has just been relegated to the background of a concept. But Justice Veeramantri goes ahead and gives a lot of examples from Oriental culture and civilization and say that sustainable development is a customary international law. While that pronouncement is very impactful, it has influenced numerous judicial decisions across the world. And in terms of scholarship, much more than the majority judgment. As I said, you need to look at the context and impact. So when you look at the actual method in which the Justice Veeramantri has framed the debate and the majority, in practically it doesn't make any difference. The majority judgment says sustainable development is balancing economic development and environmental law protection. Justice Veeramantri says there is a right to life and right to environment is part of that. But at the same time, there is a right to development as a human rights. So you need to balance. So the point is that in the actual scenario, the majority and the dissenting did not make any difference. Neither the Justice Veeramantri could put his dissent and show that this is how this balancing can be attained in that particular case. The latest case going away from or going forward from Justice Veeramantri, as I said, again the dissenting opinion needs to be contextualized. The latest one in the ICJ's opinion, provisional measures on the Israel. If you look at one of the judge from Uganda has dissented in regarding all 6 provisional measures. In fact, much more than whatever the Israel's appointment of the ICJ nominee. And she goes on to say that, yes, this is a political dispute, it's not a legal dispute, so that is the reasons for her dissent. See, that kind of a dissent, at least in my view, it appears problematic. Most of the decisions which comes before ICJ will have undertones, but ICJ is is duty bound to look at the legal aspects and do that. So any kind of a dissent before we celebrate, yes, it needs to be looked at with context. Thank you.
Thank you, Dr. Selina Jolie. And now may I request Professor Amita Singh to deliberate on the issue.
Hello, everyone. I prefer to stand here and speak because I was wanting to hop out of that chair where the saris get stuck, the sari unfriendly chairs. All right. So, very good evening to all of you, and especially to Honorable Justice Soman Sen and the wonderful family of Justice Radha Binod Pal, and of course the brilliant organizing team of the Honorable Vice Chancellor, Professor Chakravarti, and Saheli, and all the young ones around hopping in and out to help us out, feel very comfortable. One is sitting here, Ritvik is there, and giving us ideas in the process of interacting with us. In fact, the whole platform of my talk begins from where Justice Soman Sen initiated and stopped. That's about dissenting notes in the court. Dissent is an important thing, we accept it. And then a dissenting opinion in such a regimented proportion of our society which is there as courts is an extremely insightful and at the same time a brave act. And if we look at, and Justice Soman Sen has already given us a trajectory of dissents that this country has got in the courts, from the courts, we know that there has been initially some kind of an opposition to the dissenting judges, but over the years as generations moved on, they realized that that is what was sense. And I had the experience of a recent dissenting judgment of Justice Nagaratna in the minerals and mining case, where the whole bench was on one side and she, the woman judge, on the other side, and she said, and important thing was that she linked the mining with center-state relations and state versus state peer group competition. And then I realized that how do you study a dissenting judgment? Because a dissenting judgment, the dissenting judge is trying to prove a fact which is mainstreamed. And you have to move out of the mainstream. To move out of the mainstream, we all have realized in our lives that whenever we have dissented, we just cannot put logic at its place, but we have to put enormous logic with evidences to prove that yes, what I am saying is right. And that is where, you know, I thought that this time when I have to speak on Radha Binod Pal at NUGS, I'm going to speak something else, not the one that I spoke last time. And for that, I had to read the dissenting judgment again. And I thought, what is it that has not been said, that has not emerged so strongly about the brilliant judge? What is the reason that he's opened up a huge amount of ideas that may influence many generations that have lived and are going to live in the court and outside the court? And that is where I begin with. I've scribbled some of the points. There are three important things that he made very strongly. Let's analyze it. The first is psychological content. We can call it a psychosocial content, a psychological content. I'll come to that. I'll first put the 3 points together. The second is the enormously important and repeatedly growing content, which has influenced social sciences and law equally strongly, is the anthropological content. And the third is the content that comes from crude governance, the concept of accountability and responsibility, something that is being said but not being said in the fashion that was created by Justice Pal. So to start with the psychological content, let's see what he said. And this is very well given in his judgment. He said, and we all know that when we stand in the court, how do you go for conviction? We also look at intent, right? Intent mens rea is an important thing. But here, what he noticed was great danger where conviction and punishment can be both based upon intent. Conviction and punishment, that means the judges, everyone is talking about the mens rea of the person to be convicted. What about the judges? Nobody looks at their intent. He was the one who looked at the intent and unfolded that enormously important analytical, psychological content in his judgment. And when I look further into it, I realized that was a period. He was a product of his time, no doubt. But he was a product of his time in which he was so influenced by the turbulence that was happening around that he had to unfold a set of ideas like gushing streams to affect and also disturb the coming generations. And what was that? There was this, at the same time, as I say, a product of his time, Charles Peirce's Law of the Mind book got published. And there was a lot of debate and discourses going on in UK and US universities on what is the law of the mind. And there was a very nicely described law of the mind. Charles Peirce said, and let's relate it to the kind of dissenting judgment that he gave, that mind is a product of the past and present and so many ideas. But between the past and the present, there are so many interconnections, a dispersion of ideas from the continuum. We just move out. A river is a stream which just doesn't flow out. River may flow out this side, that side, and after some time just leave the riverbank altogether for miles and settle somewhere else. That's the kind of ideas that move, the free ideas which move, because they are a product of mind. And Charles Peirce published around the same time that Justice Radha Binod Pal was giving the dissenting judgment, and he was talking about not just the intent or the mens rea of the convicted person, but also of the judges who deliver justice, laws, who set up laws for the vanquished, which my earlier speakers have very nicely put in, and I am borrowing from their ideas and their statements which they made. The second is the anthropological content. In anthropological content, Justice Radha Binod Pal, anyone coming out of Bengal, I love Bengal for that reason. Anyone coming out of Bengal has something very revolutionary to deliver. And that is why all these small and big revolutions have emerged from Bengal for whatever reasons. So Hilly is giving me that big laugh. But actually, I always say that. And I look back and say, yes, it is. So Justice Radha Binod Pal had spoken about in his judgment that why can't we look at the smaller communities, the smaller tribes, people who are not Occidental. They are in some Oriental terrain. Now people in Bali, Java, Sumatra, these are what small islands in themselves, but they are small nations. Tribe is a nation in itself because they have their own rules, laws, and ways of functioning. Take, for example, Jammu and Kashmir for that matter. The own culture, and we had so many years been talking about it, that it's a community in itself, and so many in Jharkhand, Chhattisgarh, and across the world. And when they are different, we say they are enemies. When they are different, we are racist. We try to eliminate them, and we have eliminated. Now, my keynote speaker, after his wonderful speech, I got some ideas. Yeah, Tutsis have been massacred. Gaza, of course, Palestinians. And I was scribbling down Bosnian Muslims. Then genocide has gone, innumerable times, Yugoslavia, and one can just spread out the curtain. It's been happening. And we are silent about it because we try not to put it under genocide because a very powerful race is doing it. And we still keep quiet. So much so that the UN representative has said, I'm not going to allow you to enter this area, and yet it is not a genocide. It's kept out of it. Now, what Justice Radha Binod Pal says, and that is an analytical, goes into history, deepening its roots, is that smaller communities are nations in themselves. They are little nations. And I think in the 90s, there was a book, The Little Nation, written by some important anthropologist. These communities are not understood. And despite the fact that they are not understood by any of the bench of the judges, they are delivering justice to them by not understanding them. And that is why he called it a victor's justice, because they are not speaking. And the benefit is with the stronger power. That's an important thing, and that led to a number of judgments. And I'll quote one, Timisha versus Russia, in which the Chechens, Caucasians, and Kurds were being massacred, but ultimately European Court of Human Rights delivered judgment in favor of these smaller communities. So that was a little relief. We still have racism when all the trash is being dumped into poorer communities, the poor nations, and even now ships and ships of trash from the West is coming down to India and China. If we analyze that, why are they the chosen grounds, despite looking very formally, growing up very fast? So the smaller nations and lesser known communities, the fact has been brought out very strongly, in which he said, he even went to the extent of saying that he questioned the juristic competence of men in very high position, and he indicated the jurists who were sitting there. And he directly almost said it, that the juristic competence is under doubt, that you may ever be sitting over there and delivering justice. Even if you don't have the competence, you don't understand these communities, and you are sitting and delivering justice for them, you better walk out. He said it straight, of course in a little milder language, but he did say that. And the third point is about accountability and responsibility, which he mentioned, and this continues to be till today an extremely important thing, and my keynote speaker has already given a very detailed analysis of it. I'll just put it in last point of mine and then I close. The accountability factor is in which he said international criminal responsibility should be taken up by those who are doing international crimes. And he said it that conspiracy, a crime, has not been analyzed anywhere, but you sit as a majority bench and say that conspiracy is a crime. It's not even a crime, it's not even mentioned anywhere, and you declare that it's a crime simply because you're very powerful, you are in a majority. And as a result, they were laying down laws for the trial of the vanquished leaders, which everyone knows that this is what was happening. So if judiciary becomes a voice of the powerful, we are going to have repeated flaws, failure of justice, and failure of law and order in the world. It's important that we have more and more replicas of Justice Radha Binod Pal in our judiciary, who could speak the facts and stand by the notions that they believe in, irrespective of the fact that who are these powerful people trying to control them. So thank you very much, and that's where I am.
I want to thank Justice. Can you guys hear me? I probably don't need the speaker. No one has ever told me ever that I need to speak more loudly, so you can probably hear me. Justice Somenson, Vice Chancellor, and the members of the Powell family, I want to say it's a real honor to be here. I also want to tell you right up front, like most Westerners, I wasn't very familiar with Justice Powell's dissent in the Tokyo trials until I found out about this panel. So in perusing his 1,200 plus page dissent, I have to say I recognized a lot of what he said. Because while I had not read his dissent before, I am pretty familiar with the current human rights literature. And a lot of what he says is echoed in the contemporary discourse of human rights today. Human rights literature, like certainly traditionally, was sort of broken into the universalist camp, and the UN has taken a very decidedly universalistic approach. And universalism is the idea that human rights apply to everybody. And that sounds great, right? Because are they human rights if only some humans get them? No, right? So obviously the universality of human rights seems really important. But I think Justice Powell's dissent helps us realize that you need to ask questions. Whose idea of rights are being imposed? Is it the global north trying to impose its governmental form on the global south? Certainly, at the time the Universal Declaration of Human Rights came out in the late 40s, basically imposing democratic forms of government as a form of human rights, that was actually a pretty rare form of government. The United States had it, Western Europe had it, but, you know, saying that, gee, that's the human condition, one can wonder about. The other thing the Universal Declaration of Human Rights did was it said intellectual property should be protected. That's a human right. That definitely advantaged the global north, right? Where was most of the R&D happening even today? Probably that advantages the global north as opposed to the global south. So Justice Paul's dissent, I think, really says you need to, you know, look at whether or not this is just a vehicle for intellectual Western imperialism, other forms of domination, sort of soft colonialism, where you know, you're now projecting power in ways that aren't as crass as actual military occupation, but is that still not respecting the rights and the autonomy of other citizens of the globe. Now, cultural relativism has problems too. There you just throw up your hands and say, well, we don't care how abusive the system is and how much marginalized people are harmed by this. That's our culture. Well, obviously, that's problematic too. And I don't think Justice Powell was calling for that. I think his dissent has informed what's come to be known as the third way, which has certainly taken over the academic literature on human rights. Doesn't always play out in practice. But the academic literature on human rights calls for this third way, sometimes referred to as retroactive legitimation, and it calls for, first and foremost, an internal dialogue in the society itself to reform norms and values more in the direction of human rights or things that would be regarded by the international community as good for everyone. And only after there's a degree of buy-in do you try to do the cross-national dialogue to sort of, mandate that. And the idea is you're much more likely to get a society to cooperate if you've gotten them to buy in. And I think the issue with polygamy recently highlights this. The Universal Periodic Review process, which is conducted under CEDAW, which is the Convention to Eliminate All Forms of Discrimination Against Women, the people doing the reviewing have said, you've got polygamy in your country, that's a problem. The receiving state can say, okay, this is what we're going to do to address it, or they can note the objection. If they can note the objection and say nothing more, which is one approach that's been taken. A few countries have just said, it's part of our culture. Well, then you're talking past each other, because the one side's saying you have to eliminate it, and the other side's saying it's part of our culture, we're not even going to talk about it. Rather than having a process where you can think about how to mitigate the harm caused by certain cultural practices in a way that would be more culturally acceptable. I think that approach is what is endemic in Justice Paul's dissent. And I think he also had a lot to say about our current international relations. Unequal power distribution is still a problem, right? And Justice Paul said he was concerned about unequal power relations between states, and he basically noted that that precludes the development of a just international law system. Until you have a community of equal sovereign states, any sort of international law is going to tend to just stabilize existing power relationships. And he was concerned that it would actually be a vehicle for dominant countries to commit injustices against less dominant countries. And obviously, he was talking about that in the Tokyo context. Victor's justice, other people have spoken about this. The novel crimes, crimes against humanity, crimes against peace, lack of due process. And I think he also made a good point that by temporally subscribing the reach of the tribunal, they limited it to basically the actions of Japan and sort of precluded Japan from bringing up the violence of the colonial era and how their actions were really defensive against Western colonialism. I also think he was troubled by the fact that the atomic bomb was by definition taken off the table by how it was structured. And I think we still have some of those problems. Others have commented on the International Criminal Court, and I would just say that the Rome Statute, from its inception, was regarded as problematic by many because of the role of the Security Council in referring cases and also having the authority to suspend. The representative from India at the Rome Conference said the referral in the Rome Statute, quote, assumed that the veto-wielding states did not, by definition, commit the crimes covered by the statute of the court, or if they did, they were above the law and possessed de jure immunity from prosecution. Not surprisingly, India is not a party. But neither is the United States, China, or Russia, which is interesting because they're on the Security Council. So that certainly gives credence to the allegation that this is about the global north exercising power and the global south being the recipient, or dominant countries, more powerful countries, less powerful countries. So I think that in many ways, the problems he identified are still with us, although I think he's given us a blueprint in some ways for addressing and mitigating some of those deficits. Thank you very much. I appreciate it.
Devashish Mitro from our Ramanarba Women's University, professor in political science. So, Dr. Mitro.
Thank you. Thank you, Vice Chancellor, Dr. Chakraborty, and all my co-panelists out here. Basically, I am the outlier. Why I'm saying I am the outlier? Because I come from a very humble background studying political science and not the legal jurisprudence that you all have or you might be having. So in that scenario, I call and I deem myself to be an outlier. Now, this outlier has a positive effect if you say in a statistical mode of way, because I try to understand these kind of things where the statistics does matter a lot. What is the advantage of the outlier? The advantage of the outlier lies herein that when you take the outlier into consideration, the outlier will tell you the fact that whether your regression analysis that you have done, pardon me for using these statistical words, but when you are doing this regression analysis, this outlier will tell you the fact that why your data is actually validating the point of hypothesis that you are trying to make. Now, this is the point of consideration that I would like to bring in fact, that we still, at this point of time, at this venture, at this consideration, we have talked about, we have tried to understand, we have listened to the deliberation as our honorable keynote speaker, as my co-panelists and all have been talking about, and of course Justice Sain has talked about the exact connotation of the entire process of this deliberation of what is actualizing this kind of a thing that is going to come out while we are deliberating, while we are discussing about this role of dissent. Now this role of dissent and this outlier is the same. Why I am saying so? The examples are there and you have all heard about all these examples. Examples are there in our country, examples are there in the UN Court of Justice and all ICJ and everywhere. The very basic thing that I have in my mind when I got this opportunity, I would like to deliberate on three basic things and try to keep it very short and simple. First, the very basic features that Justice Radha Binod Pal have achieved. One. From there, I would like to take the point of consideration that we need to talk about. And the last, and the point that I need to, myself, I have the question that why he? Why he has been chosen? Why not someone else? Because this is the most considerable point that we need to make while we try to make an audacious attempt of understanding a 1200 plus page of judgment, not only through the legal point of view, but also from the specific point of view, some socio-political context of Indian surrounding and Indian politics at that point of time and also at this point of time. It is not only he, it is also why now. That is the question that also begs me, but due to constraint of time and due to several other factors, I may not be able to go into that, because I also feel myself that I do not have such a expertise in that matter. But coming from the field of political science, I would just to lay out some of the basic things that I think that are very understandable and would like to draw your attention onto that also. There are basic three things which I find it very interesting in these 1200 pages, although I have not gone a single line of it. It is all through Googling the entire fact that I got it. But the three things that I came to understand, the first one is, hopefully you may agree with me also. The first one is that he assumed a very basic questions of foundational assumptions of tribunal's legitimacy. Please correct me if I am wrong. So that is number one. The number 2 point is that he pushed the entire legal debate forward by documenting the robust counter-argument point in the ICJ. That is the second point that I think that is very important, and that's very fascinating too. Because till date, as we speak, we are speaking on his role of dissent, not the other. There are any other examples that have been there elsewhere or before him. And number three is how he demonstrated the judicial independence despite formidable political pressure. This is the point that I would like to mention. Because because I told you, I am the outlier and coming from the political science background, I would like to understand the power functioning of the judgment, the power functioning of his understanding, and the power functioning of the entire coterie that is being going on. So these are the three basic things that I would like to delve upon. So if we go from that point of view, these contributions have collectively make Justice Pal shape the environment of his dissent that I may, if you ask me to do so. But now the point is why? What are the basic three things that he has given us to understand? In order to answer this, although I don't know whether it will be formidable to give me the explanation right now because I do not have much of a research behind it, but still I'm just putting up the question so that it can be further analyzed and it can be further discussed and it can be further went through, because research is, we all know, is an evolutionary, it has an evolutionary path that need to be tread. So, by giving the answer to this, the first and the foremost thing that it comes to my mind is that the first thing that is the rich tradition of the robust intellectual debate and the anti-establishment movement that was there in Bengal at that point of time, which Dr. Singh has also mentioned about. And therein, I know it's very oversimplistic to attribute. I understand that. It's a very oversimplistic to attribute at this point of time where we do not have any kind of a thorough and pragmatic research behind it. But I still think that this can be the point of discussion that we can at least start with. Because if we see that the entire trials solely or even primarily cannot be attributed to a psyche which is regional or very local. But when we see that there is a tradition of intellectual and political dissent in the historical context, why I am saying so? Because Bengal has often been at the forefront of India's social and political front, from the Bengali Renaissance 19th century to the thriving revolutionary and the nationalist movement in the early 20th century. There are numerous anti-establishment, that was I'm trying to harp on, that there are numerous anti-establishment thinkers, reformers, activists, you know the name of all. For example, Raja Rammohn Roy, Ishwar Chandra Vidyasagar, and later Subhash Chandra Bose, who emerged from Bengal. It also happened to witness one of the most radical movement. For example, you have the Tebhaga Andolon, you have the Naxalite movement, adding to the reputation of the questioning of the authority. That's what I want to point it down. And the second point I want to note is that there is a deep kind of a resonance of intellectual clarity and intellectual culture, where Bengal has a deep-rooted culture of what I speak about, what Partho Chatterjee has also spoken about. Hopefully you have heard about Partho Chatterjee's. He has spoken about Adda, where Adda becomes the informal intellectual discussion, vibrant literary circles, and robust political debate. This milieu, the milieu of the Adda, may encourage individuals to develop. I'm again pointing and trying to harp a point that I'm not emphasizing or de-emphasizing his fact about legal luminaries. I'm just trying to say what happens to be the main point of discussion where he is the main focal point. So this milieu of the Bengali culture may encourage individuals to develop strong convictions and a willingness to challenge prevailing norms or authority. The number two, which I think is it has a complex influence, that this kind of Bengali cultural milieu has a complex influence over his dissenting opinion. Because Justice Pal had a strong academic background in law. For example, he was a professor and later served on India's highest courts. His worldview would have been shaped by multiple factors. For example, professional training and legal philosophy, exposure to international legal debates, his personal moral convictions, and everything. But his dissenting voices on international benches are common across various ranges. For instance, there are judges which we can say, for example, from Sri Lanka, from Japan, who have issued powerful minority opinions in various international courts. But what I am trying to point it out, and that's how I will try to conclude, is that there is a symbolic resonance of Pal's dissent in this trial judgments. Because in Pal's judgment, one can say that Bengal's public intellectuals as Justice Pal's stance might fit within a broader tradition of public figures. Again, I am trying to cite an example of Rabindranath Tagore criticizing the nationalism. Again, I'm trying to the later-day Marxist intellectuals who questions the mainstream power authorities. However, each figure had its own dissent, was rooted in a specific historical and ideological context. But those contexts, if taken together, and if there is a balance between the cultural context with his, Justice Pal's individual's agency, then that cultural conditioning and this individual decision can help us to understand why he. That's all. Thank you.
Can I speak? Okay. Yeah, good evening, all of you. So the topic for today, the role of dissent in shaping or developing the international law. So on the eve of the birth anniversary of Judge Radha Binod Pal, so we gathered here to discuss because he delivered a celebrating dissenting opinion comprising of more than 1,000 pages way back in 1946 as part of the Tokyo trial. So the significance of the dissenting voice of Judge Radha Binod Pal, so we can highlight through in the form of certain points. So he was focusing upon certain key issues. One is the application of ex post facto law, the retroactivity of application of criminal law. Then another important issue, so it was critical, that is victor's justice. And then he was also discussing from the context of the absence of the fair trial standards, issues of jurisdiction. So these are the key aspects comprising as part of the dissenting opinion. So how Judge Radha Binod Pal dissenting voice subsequently guided the international society. There are two facets. One is the dissenting opinion of Judge Radha Binod Pal. It led to the development of international law, shaping and reshaping the international law. particularly in the field of international criminal law. Because at that point of time, when he dissented in 1946, so we have to coincide the decolonization process. Many of the Asian and African countries slowly getting independence, they began to question the Western hegemonic character over the global South, how the Western countries, they dominate in the form of underlining certain principles as part of international law. So because initially it was questioned by Justice Radha Binod Pal through his dissent, because only the losing side, particularly the Japanese military officials, they have been subjected to prosecution. On the other side, it was left without any prosecution or punishment. So perpetrators of only one side, they have been caught up and they have been punished. So that's why he branded the entire process as victor's justice. He was very critical in that particular aspect. So it guided the dissenting voice, it guided the idea of emerging new voice, that is to protect the interest of the third world countries, newly independent states. They wanted to question the legitimacy of international law, the existing international law. So in that way, slowly we are able to see the emergence of the different approach, that is the stand taken by the third world countries, now presently known as 12, the third world approaches to international law. So we have to say Justice Radha Binod Pal, he was the beginner to question the conduct of the practice of the Western states, how they invaded the territories and how they began to prosecute the non-European society, the Japanese military officials. So this is one aspect. And further to say, the development of international criminal law did not end with the Tokyo trial and Nuremberg trial. Thereafter, international community, it was focusing upon the development of the subject. Now we are able to see the emergence of new set of crimes, various forms of jurisdiction, and various instances of ensuring international justice, but not in the form of the victor justice or ex post facto law or retroactivity of criminal law. So till now, there was no such instance. Because Justice Radha Binod Pal dissenting opinion, it protected the international community. States, they did not look into back and they did not try to invoke that type of situation. And then the other aspect is concerned how dissenting opinion, it is able to influence the shaping of international law. So whether it is international law, national law, we know dissenting voice, it has its own significance. In various jurisdictions, as earlier speakers, they pointed out, so we have Justice H.R. Khanna, so how is dissenting opinion, it influenced the subsequent development of law, the legal jurisprudence in the Indian courts. Similarly, we can take the practice of the American courts. We take the dissenting voice of Justice Harlan in 1896, because he dissented when racial segregation, it was legitimized. But after the 50 years, in the Brown versus Board of Education case, judges, based upon the dissenting voice of Harlan, said they relooked and gave the decision so to end the racial segregation in the American schools. So in that way, dissenting voice may not have immediate effect, but over the period of the time, definitely it will influence. It will lead to the shaping of law, it will lead to the development of international law. In terms of international law is concerned, we can take some cases like the Southwest Africa case, 1966. There, Liberia and Ethiopia, they tried to end the occupation of the Southwest Africa, the present Namibia, by South Africa, because a kind of a public interest litigation. So they tried to raise. That was turned down by the International Court of Justice. Then Judge Tanaka from Japan, so he dissented, because court was not ready to entertain the petitions of Liberia and Ethiopia when they tried to liberate Southwest Africa from South Africa. But subsequently we know how the concept of erga omnes obligation and how it was recognized in the subsequent cases, and because of that only now we are able to see when South Africa filed case against Israel, court is ready to entertain, because it's a kind of an obligation across the international community. Anybody can question the wrongful conduct of the other state. It's a kind of a public interest litigation within the parameters of the Genocide Convention. So Judge Tanaka's dissenting voice in 1966, subsequently it was able to influence the international community, and we are able to see the emergence of a new principle of international law. Similarly, there are various important judges, like as earlier speaker said, Judge Veeramantri, Christopher Veeramantri of Sri Lanka. So he dissented in the leading case of ICJ in 1996, the legality of use or threat of nuclear weapons. Even though the court was deeply divided, Judge Veeramantri's opinion, it commands the highest respect as far as the jurisprudence of the court is concerned. Similarly, in terms of the command responsibility, because command responsibility, it speaks about the responsibility of the commanders for the wrongful conduct of the subordinates in the event of the war situation. So at the end of the Second World War, one of the Japanese military generals, General Yamashita, so General Yamashita, he was prosecuted, and in the final appeal, he was sentenced to death by the American Supreme Court. And that was very much criticized by one of the dissenting voices in the American Supreme Court, Justice Murphy. He gave a strong dissent, because Yamashita was punished without any fault of his own. He was not able to control his subordinates because of the failure of the communication system. The entire communication network, it was destroyed by the American forces. So that's why he has no information what was going on at the subordinate level. His subordinates, they were on the rampage. They committed so many atrocities for which he was punished. And that was criticized by Justice Murphy. Subsequently, now if we see today, the law, it was developed relating to the command responsibility through various international legal instruments as well as various judgments of ICTR. They really reflect the voice of Justice Murphy of American Supreme Court. So in that way, we can see how dissenting opinion, it is able to shape and it is able to enhance the development of international law. Not only international law, even at the national level also, we can see so much of contribution from the dissenting voice. The guiding principle we can take Judge Radha Binod Pal. So way back in 1946, he dissented strongly and subsequently guided both at the national level as well as at the international level. And that's why we are able to see so many dissenting voices across various courts and tribunals. Thank you.
Now our last speaker, Mr. Rohini Singh from Jindal University. So the associate professor there. Please introduce.
Am I audible? Okay, great. I have the unenviable task of being the last speaker, which is always very difficult. Half of you look asleep, rightfully so. It's almost 8 p.m. The other half looks hungry, again, rightfully so. I'm going to time myself and keep it very short, somewhere between 5 to 6 minutes. Almost everything has already been said about Justice Pal, the dissent, the different context in which dissent operates. So what I'm going to do is tell you 3 stories about 3 people you've already heard of. One is, of course, Justice Pal, the other is Justice Veera Mantri, and the third one is Justice Zafrullah Khan. We've spoken of the Southwest Africa case where Judge Tanaka gives the dissent, but there's another interesting person in that case, which is Justice Zafrullah Khan, who, while he doesn't actively pen a dissent, ends up doing a series of interesting things that may count as conducts of dissent. So what I'm going to talk to you about is what does it mean to perform a dissent in different international courts and tribunals? And in other words, then how can you read these dissentient judgments and identities in their specific context? Professor Jolly had to leave us because she has a flight to catch, but when she said contextualize the dissent is very important. Different judges have had different moments in different kinds of tribunals in different points in history, and those moments have led to the curation of certain kind of dissent. So what do I mean by performing a dissentient identity? What I mean by that is, of course, everybody is a product of their context and time, but there are other socio-political, cultural conditions and factors that mobilize the space from where your dissent is emerging. So performance here is, it's compared to a theatrical performance of what is it that you do. It's not an artificial curation of something. We all perform. We perform as teachers, we perform as people, we perform as students. So performance is simply an articulation of that particular set of contexts and circumstances you're coming from. Now, very quickly, let me tell you these 3 stories. About Justice Pal, we all know. We've been talking about him not just here, in the previous conference as well. We had questions about where his political motivations are coming from, and for that, if you're interested, there's an excellent piece of work by Professor Ashish Nandi, also by Professor Milindo Banerjee, who's a historian. They've all located Justice Pal in these different spaces, politically, intellectually, from where his dissent emerges. So his story we know. He was sent to the tribunal almost as an afterthought, spent a lot of the time not necessarily sitting on the bench, but speaking to his fellow judges and talking about the different political implications of what this sort of a judgment may or may not do. You also know that Nuremberg was unanimous, Far East was not, and that has a significant bearing, not just in the context of his courage, his conviction, and so on and so forth, but he was speaking from the middle and the heart of the colonial context. What he was experiencing in the tribunal was also a reflection of how international law systems, processes, and institutions work. Now, this sort of characterization of the dissentient identity comes from within the tradition of what we call third world approaches, decolonial, anti-colonial critique, and so on and so forth. Following Justice Pal's story, which we now are well versed with, let me also tell you about Justice Zafrullah Khan. I take it many of you do not know of Justice Zafrullah Khan. Not much has been written about him or said about him. There is an excellent piece of work by Professor Victor Katan on his time at the ICJ during the 2 phases of the Southwest Africa cases. As we were just told by Professor Sudhakar, in the first phase of the case, Ethiopia and Liberia bring a petition before the court saying that South Africa's apartheid in the region needs to be stopped. Though the court actually takes cognizance of this, they later go on to say, on jurisdictional grounds, Ethiopia and Liberia should not be here. What we see here is the beginning of something that we now call subaltern internationalism. It's the same kind of jurisdiction that grants South Africa the locus standi to come before the ICJ and say, we are here to speak on behalf of Palestine. And as our keynote speaker has so beautifully articulated, much needs to be done in international law, but much has also been done through these different kinds of critiques and dissents, where you're able to take cognizance of issues of international consideration that should affect one and all. Anyway, so Zafrullah Khan is nominated to the bench due to very interesting set of circumstances, certain kinds of internal politics, which involves 2 other judges, Judge Fitzmaurice and Judge Percy Spender. He's forced to recuse from one of these cases. And it's around this time that the rather ill-fated judgment is passed. He comes back to the court later in the 1971 second phase of judgment, where he's the president of the court. And as I said, while he doesn't really write the dissent, there's a lot of political mobilization that goes on drawing from his time in the United Nations General Assembly as a political representative, speaking up back in the day against the separation of Palestine and so on and so forth. So he's also drawing from different contexts, including having been a judge in pre-partition India. So there's not just the impact of colonization, there are other kinds of context that informs what he goes on to do at the bench. And finally, you have Judge Veera Mantri, who writes the very, very famous dissent in the nuclear weapons case. There are many things that he says in the case, I'll not speak about that. But what he fundamentally says is, the court misses an opportunity to pronounce on the illegality of nuclear weapons. Rather than invoking the clauses of self-defense, whereby the court goes on to say that if you're attacked with a nuclear weapon, specifically under those circumstances, you might want to defend yourself with one. Veera Mantri brings in questions of greater contemplation, questions of humanity, to say that under no circumstance could you imagine a weapon like this be permitted to use if all the states had context and consent of why and how such a weapon should be used. Now, in his dissent, he's also drawing from different contemplative traditions. He's drawing from his experiences of Buddhism, he's drawing what you now know to be general principles of international law, which for those of you who are familiar with sources of international law, is the third source, placed right after treaties and customary international law. What he's doing, what Justice Pal has done as well, is drawing from different intellectual traditions, expanding the understanding of what we think is knowledge, and attributing a certain kind of seriousness to what would otherwise get passed off as local traditions and customs of different places. So they all come from these different jurisprudential contexts. They certainly come from political context of decolonization, of partition, of the long legacy of imperialism in international law. They're all working as judges in institutions that are shaped not just by Eurocentric international law, but are also trying to fight against it. So in many ways, their macro stories and biographies map on to the larger context that they are fighting. So there are many ways to think about dissent. Dissent as countercultural, dissent as multiple opinions and interpretations of law, but I also want you to think of dissent as articulating a different kind of politics as against a more mainstream, Eurocentric, imperial, colonial, patriarchal and capitalist one, which is what each of these dissents do. Again, this is not to say that this is sort of the tone in which they carry on in their further work, but each of these specific dissents speak to that. So I would invite you actually to read more historical biographies of judges and the way they navigate these various institutions and think of how these dissentient personalities and identities have been carved. I'm going to stop, as I promised, 5 minutes. Thank you.
So within 5 minutes, we can take 1 or 2 questions.
Before that, I think it's Rohini that co-authored that article. There you mentioned about Zafarullah Khan. Am I correct? No, in that, yes, you are the co-author. Now, I think this, apropos to what you said, Professor Mitro, Dr. Radha Binod Pal was nominated in the year 1946 when we were under the British rule. But when he delivered the judgment, India became free. That's in 1948. The judgment was delivered in 48. So it's really interesting, could be a puzzle, could be a surprise about his choice, because by that time, 2 things are very, very clear. About his choice to the international. He was nominated by the British government that time, so his choice.
No, I have been questioning about not his
No.
I have been questioning about the authorities' choice.
No, saying authorities, that means the British, why did they choose, because there are 2 things operating against him. This is a surprise. So it's a yes. So it's a surprise to the system maybe that in 1946 when he was appointed, by that time 2 things are against him. He was known to be a nationalist, although he was a judge. The second thing was that his tenure as a vice chancellor was not renewed. But surprisingly, when in 1954 his candidature came up for consideration, the British supported him, although he was not the initial nominee, if I'm correct. The reason I feel is that of the amount of fearlessness and impartiality he exhibited sitting in that bench. So they said the opinion was that we should have someone who can have another view. And that was the reason for which the British, although they delivered the judgment against them, they supported, if I am not wrong, they supported Dr. Radha Binod Pal over Zafarullah Khan. At the end of the day, they respect him, although it may not serve their purpose.
But there's another side of the story from where it goes. The entire Nehruvian legacy, which is so much of right to freedom, rule of law, and freedom of speech and expression, has deliberately suppressed the entire guidelines about this judgment. And that is where the fallacy lies, what I think about. Now, that's why I question. That's the thing. That's why I question. Why he? Because when the British chosen him, the British must have thought about the Japanese, the Indian, the counter forces, allies, axis, and all these things. But when Nehru has a choice, must be after 50, he could have given the recognition that he should have, ought to have. And that's where lies the fallacy. That's what I have been asking. Why?
No, he was certainly that what Dr. Radha Binod Pal deserved during his lifetime, he did not get that recognition, although he served the United Nations for almost up to 67. So,
as an Indian, we always say that whenever Westerners give us the recognition, we deserve the recognition after they give us. Now here the other way around. The British chose him, but we didn't recognize him. There lies the fallacy.
Now, any question from students? Though we have already crossed. Anyone having any query from the panels? Otherwise, it is my duty to express my thanks, gratitude to all the panelists for their different dimension of views. So we have to definitely enjoyed all of us. So thank you all and thank all the participants here. We may now ask Sohaili to conclude that.
After a rigorous round of assessment, we are about to declare the results for the first Justice Radha Binod Pal essay competition. The second runners-up has been conferred to Nilina Banerjee from the National University of Advanced Legal Studies, Kochi. So first runners-up or second has been to Harshit Pastaria, National Law Institute, University, Bhopal. And the first has been conferred to Debangshu Sheel, Department of Law, University of Calcutta. May I request our Honorable Justice Shoman Sen as well as our Honorable Vice Chancellor N.K. Chakraborty sir to kindly give away the token representation of the prize-winning money as well as the certificate. To Mr. Debangshu Sheel, the other two students could not travel to Calcutta at such short notice. Therefore, we just have the winner, Mr. Debangshu Sheel. As for the other two winners, the amount of money shall be, of course, NEFT done very soon. So the first prize winner to Debangshu Sheel, rupees 50,000 rupees, is being conferred on May I request all our esteemed guests to kindly join us for this one photograph. I'm sure Devangshu would like to keep it for as part of his academic career. May I request Professor Murthy to kindly join us, Mr. Pal to kindly join us as well. And we also have one of the reviewer with us, Mr. Proshanjit Pal, who's distinguishedly read all of these essays, apart from the other reviewers, of course. May I request the entire audience to give a big round of applause for this young boy, Devangshu. Thank you very much for everyone who's gathered here. We are extremely, esteemedly proud that we have such distinguished guests and scholar at this second memorial lecture. As per the conversations and discussions, we will be opening the second essay competition very soon. And we hope this is just not the end of the discussion on Justice Radha Binod Pal, and this is just the beginning and the seed is sown taken further. Thank you everyone. The high tea is right outside. I would request all the students to kindly join us for high tea. Thank you everyone.